affidavits. The state filed an answering affidavit to which both Mr. Zuma and Thales replied. The matter subsequently served before me as an opposed application on 24 April 2025. It is apposite to mention that the relief based on section 1721B of the Constitution is only set out in Mr. Zuma's notice of motion, not Thales's notice. Be that as it may, it is my view that given the history of this matter, there is good reason to consider whether Thales succeeded in making out a case for a declaratory order set out in paragraph 2 of Mr. Zuma's notice. I begin with the question whether it is competent for this court to grant the relief sought in prayers 1 and 2 of the main application. But before I proceed, I pause to first deal with the position of Mr. Zuma. The success of Mr. Zuma is in no uncertain terms conditional upon the success of Thales. This much is evident from his notice, where he states inter alia that at the hearing of the main application, he will bring a conditional counter application for an order that in the event of the relief sought by Thales in the main application being granted, he will seek an order setting aside his prosecution. The above averment is repeated verbatim in paragraph 4.3 of Mr. Zuma's supporting affidavit. In paragraph 58, Mr. Zuma made the following remarks, and I quote: "This counter application is essentially premised on the basis that the case against the first and second accused persons is symbiotically conjoined and cannot be artificially separated. My emphasis, to put it simply, it is in my view totally impossible for the state to pursue the case against me if indeed the prosecution of the second accused must be terminated upon the pleaded grounds as it must." Close quotations. I am therefore satisfied, regard being heard to the above, that Mr. Zuma's success is dependent on Thales's success. If Thales's case fails, it follows that Mr. Zuma's case must also fail. I now revert to the question of whether it is competent for this court to direct the state to stop the prosecution in accordance with the relief sought by Thales in prayer 1. Section 6 of the Criminal Procedure Act 51 of 1977 makes it clear that the power to withdraw a charge or to stop the prosecution rests with the state. Section 6 is divided into subsections A and B. Subsection A, which is not relevant for the purposes of this present application, deals with the withdrawal of a charge by the state prior to a plea. Such withdrawal does not entitle an accused person to an acquittal. The second part, which is applicable in the present application, provides as follows, and I quote: "An Attorney General or any person conducting a prosecution at the instance of the state, or any body or person conducting a prosecution under Section 8 may be, at any time after an accused has pleaded, but before conviction, stop the prosecution in respect of that charge, in which event the court trying the accused shall acquit the accused in respect of that charge, provided that where a prosecution is conducted by a person other than an Attorney General or a body or person referred to in Section 8, the prosecution shall not be stopped unless the Attorney General or any person authorized thereto by the Attorney General, whether in general or in any particular case, has consented thereto." Close quotations. Again, subsection B makes it clear that the power to stop the prosecution after an accused person has pleaded to a charge rests solely with the state. See S vs. Ngubane, 1985, 3 SA 677A, S vs. Gumbi and others, 2018, 2 SACR 676 SCA, paragraph 10. It also makes it clear that the court can only return a verdict after the state has exercised its exclusive right to stop the prosecution. There is nothing in the Act that empowers the court to direct the state to either withdraw a charge against or stop the prosecution of an accused person. I am therefore satisfied that it will be incompetent of this court to grant the relief sought in Prayer 1 of the main application. The relief sought in Prayer 2 is conditional upon the grant of the relief sought in Prayer 1. Put conversely, the court can only acquit an accused person who has pleaded to a charge if the state, in the exercise of its discretion, has stopped the prosecution. Mr. Roux readily considered, correctly in my view, that the prosecution of an accused person is the prerogative of the state. I now proceed to deal with the question of whether there is justification for the grant of the declaratory order in accordance with Section 1721B of the Constitution. Section 1721B permits the court to grant an order that it considers to be just and equitable in the given circumstances when dealing with a constitutional matter. It was thus contended that the just and equitable order will be to decide that Mr. Zuma and Thales will not receive a fair trial if their prosecution were allowed to proceed in the face of the deaths of Messias Pietermaritzburg and Alain Tetard. It is common cause that Messias Menon and Tetard died on 31 December 2020 and 5 September 2022 respectively. It was contended on behalf of both Mr. Zuma and Thales that without their evidence, both Mr. Zuma and Thales' rights to a fair trial will be severely prejudiced. In support of their cases, both Mr. Zuma and Thales relied on Section 35.3 Roman Figure 1 of the Constitution, which provides that every accused person has a right to a fair trial, which includes the right to adduce and challenge evidence. It is not an issue that at the relevant times or at the times relevant to the charges leveled against Mr. Zuma and Thales, Messias Menon and Tetard were employees of Thales. Mr. Menon was the director of Thales from its incorporation on 21 May 1996 until 1 April 1998. On 24 April 1998, he was appointed as the Chief Executive Officer of African Defence Systems Pty Ltd, another entity which features prominently in the state's case against Thales. He again served as Thales' director from 1 October 2002 through to 10 December 2010. Mr. Tetard, on the other hand, served as Thales' director from 1 April 1998 through to 30 January 2002. In support of its case, Thales alleged in its founding affidavit that the importance of Messias Tetard and Menon in the criminal trial against Thales is unquestionable. They are the only individuals, so it was argued, that will be able to testify on behalf of Thales and also to assist Thales in challenging any evidence led by the state against it. When joining issue, Mr. Zuma reiterated in paragraph 59 of his founding affidavit that the deaths of the two material witnesses have a similar or equal effect on the evidence necessary to convict him. I will revert to the state's answer in due course. In the papers, the parties spent a considerable amount of time on the issue of delay in the prosecution of Mr. Zuma and Thales. It is common cause that there has been a considerable delay in the prosecution of both Mr. Zuma and Thales. However, in light of the view I take of this matter, I do not consider it appropriate to engage in the exercise of attributing blame to any party for the delay. I am satisfied that sufficient facts have been presented to the court to consider whether Mr. Zuma and Thales' rights to a fair trial will be severely prejudiced as contended. In support of their contention for and against the grant of declaratory relief, both the state and the accused relied on Potma versus Els and others, 2009, ZACC 27, 2010 to SA 622CC. The facts in Potma can be summarized as follows. The appellant, Ms. Potma, who was 51 years old at the time, had instituted criminal proceedings in the magistrate's court against the respondent, Mr. Els, for rape that had taken place 39 years before, when Ms. Potma was a 13-year-old schoolgirl. While awaiting trial, Mr. Els approached the High Court for an order permanently staying Ms. Potma's private prosecution on the basis that the undue delay in instituting criminal proceedings amounted to an unfair trial. The High Court found in his favor and permanently stayed his prosecution. Aggrieved, Ms. Potma approached the Constitutional Court directly, challenging the decision of the High Court. When finding for Ms. Potma, the Constitutional Court criticized the High Court for having given consideration only to three factors, namely the length of the delay, the reasons for the delay, and the trial prejudice caused to Mr. Els by the delay. The Constitutional Court made a very crucial observation to the effect that it is not the interests of the accused person that have to be borne in mind when considering fair trial rights, but also the interests of the society. I am of the view that in a request that will result in the acquittal of an accused person without production of evidence in a matter of such a magnitude, the societal interest is but one of the factors that the court should view in a serious light. The Constitutional Court further held that a factor that is of central significance should always be the nature of the offense. It proceeded to say, and I quote, "The more serious the offense, the greater the need for fairness to the public and the complainant by ensuring that the matter goes to trial." Close quotations. It was correctly conceded in argument that in order for Thales to succeed, it had to advance exceptional facts in support of its case. A court can only shut the door to the prosecution if it is satisfied that the continued prosecution will cause both Mr. Zuma and Thales irreparable or insurmountable trial prejudice. Regarding the terms irreparable or insurmountable trial prejudice, the Constitutional Court remarked as follows, and I quote, "Irreparable prejudice must refer to something more than the disadvantage caused by the loss of evidence that can happen in any trial. Thus, irretrievable loss of some evidence, even if associated with delay, is not determinative of irreparable trial prejudice. Irreparability should not be equated with irretrievability. Clearly, potential witnesses who have died cannot be revived. Documents that have gone permanently astray may not be capable of recreation. Irreparability in this context must therefore relate to insurmountable damage caused not to sources of testimony as such, but to the fairness and integrity of a possible trial. Put another way, to say that the trial has been irreparably prejudiced is to accept that there is no way in which the fairness of the trial could be sustained." Close quotations. There are two issues raised by the state in response to Thales' case that require consideration. Firstly, The state disputed Thales' contention that without the evidence of Messias Third and Maynor, Thales would not be able to adduce its evidence or challenge the state's case. In amplification, the state contended that Messias Sheikh and Threeman and Miss Guerria were available to assist Thales in its defense. In reply, Thales contended that both Mr. Threeman and Miss Guerria will be of no assistance to Thales because they did not have the first-hand knowledge of the events surrounding the offenses charged. Thales further contended that the calling of those witnesses will require Thales to waive its rights to legal privilege, and added that in any event, the evidence of Mr. Threeman and Miss Guerria will have no probative value. Firstly, it is clear from the above that there is a dispute regarding the availability of Messias Sheikh and Threeman and Miss Guerria as witnesses for the defense, which cannot be decided on the papers. Given the fact that this matter is to be decided on the papers, it is my view that that dispute should tip the scales in favor of the state. In that regard, see Plascon Evans, Paints Ltd versus Van Riebeck Paints Pty Ltd 1984 3SA 623A. A second dispute relates to the value to be attached to the evidence of Mr. Threeman and Miss Guerria if they are called as witnesses. The argument that the evidence of these witnesses will have no probative value is, in my view, speculative. It has been held that it is not sufficient for an accused person applying for a permanent stay to rely on hypothecated prejudice. It must be actual significant prejudice. In that regard, see Sanderson versus Attorney General Eastern Cape 1998 2 SA 38 CC, 1998 1 SACR 227 CC, 1997 12 PCLR 1675 CC, paragraph 38. The actual position regarding the value to be attached to the evidence sought to be adduced by Thales will only be known once that evidence has been presented. The question whether there will be trial prejudice which might result in Thales not receiving a constitutionally fair trial is a matter for the trial court, or at least for assessment as and when it arises, if it does arise. Whether the right to a fair trial is infringed is the matter best decided by the court. In that regard, see Key versus Attorney General Cape Provincial Division and another, ZACC 25, 1996, brackets 4SA 187, 1996, brackets 2SACR 113, 1996, 6 PCLR 788 CC, para 13. I might just add that the standard of proof in criminal and civil cases is completely different. There is no duty on an accused person to prove his or her innocence. Instead, it is the state that bears the onerous duty to prove the guilt of an accused person beyond reasonable doubt. All that will be expected of Thales at the trial will be to advance a version that is reasonably, possibly true, S versus V 2001 SACR 453 SCA, paragraph 3. The second point raised by the state, which I consider to be of vital importance, relates to the stance now taken by Thales vis-a-vis the stance it took in its application for the permanent stay of prosecution regarding the availability of Mr. Third as its witness. In the permanent stay application in November 2018, Thales alleged that Mr. Third was not prepared to assist in any way. CS versus Zuma and another and related matter 2022 PCLR 158 KZD for the permanent stay application. He was not prepared to return to South Africa or to testify in South Africa or any other forum should a trial take place. In support of its case, Thales filed an affidavit deposed to by Mr. Third, dated 11 March 2009. In the present application, Thales has now adopted a different stance altogether. It now states that had Mr. Thales been alive, he would have been an invaluable witness for the defense. In response to the state's case, Thales missed the point completely and focused his attention on the assertions made by the state in reply regarding Mr. Thales' credibility as a witness. That, in my view, is beside the point. It is not the state that seeks a declaratory order, it is Thales. The duty is on Thales, not the state, to persuade the court that without the evidence of Mr. Thales will not receive a fair trial. In doing so, it will have been expected of Thales to, at the very least, indicate to the court that at a certain point in time, Mr. Thales changed his mind and undertook to assist Thales in his case. Without such evidence, one is tempted to conclude that Thales conveniently decided to move the goalpost in order to bolster its case. Regarding Mr. Maynard, it was contended on behalf of the state that he was not a central actor in the events giving rise to the charges against Thales. It is common cause that he was not an officer or employee of Thales between April 1998 and the third quarter of 2000, when most of the events occurred. As aforesaid, he only represented Thales before April 1998 and thereafter late in the year 2000 onwards. It appears to be common cause between the parties that he testified in Mr. Sheikh's trial. Mr. Roux took issue with the state's suggestion that it is up to Thales to introduce the evidence of Mr. Maynard tendered in Mr. Sheikh's trial. With regard being held to the facts at my disposal, it would, in my view, be speculative to make a factual finding on the value of Mr. Maynard's testimony that was presented at Mr. Sheikh's trial. At this stage of the proceedings, there are too many factors this court will have to speculate about, which, in my view, should best be left for consideration by the trial court. In S. v. Sanderson Supride, in paragraph 38, the court held, and I quote, "Barring the prosecution before the trial begins is far-reaching. Indeed, it prevents the prosecution from presenting society's complaint against an alleged transgressor of society's rules of conduct. That will seldom be warranted in the absence of significant prejudice to the accused," close quotations. On facts presented to court, I am not persuaded that it was sufficiently established that Thales will suffer irredeemable, irreparable, or insurmountable prejudice if the state were allowed to continue with the prosecution in the face of the deaths of Messieurs Thales and Maynard. The court, seized with the matter, has a duty to consider all the evidence before it, including the non-availability of defense witnesses, before returning a verdict. I am not persuaded either that Mr. Zuma's right to a fair trial will be prejudiced by the non-availability of Messieurs Thales and Mr. Maynard. There is no justification for the grant of the order sought by Mr. Zuma in the alternative, in accordance with section 1721B of the Constitution. I therefore make the following order. The application by both Mr. Zuma and Thales is dismissed. I think this is now time for us to decide what we are going to do with the case.
Yes. May I address the court?
Yes.
The court will be aware that we are in the middle of what previously had been booked as a trial.
Yes.
In the trial period, we booked from the 14th of April, which has passed, and it was due to end the first session on the 20th of June, which is to come in a week or two's time. 2 weeks' time, and then again to resume on the 21st of July to the 19th of September. So the state's first application would be that this court postpones the trial to a date convenient, which has already been booked, and that would seem to be the 21st of July. It would give sufficient time for the state to prepare, and we could run then from the 21st of July to the 19th of September.
21st of July this year?
This year, my lord, yes. That, of course, is predicated upon the availability of the court, that the court calendar, as I understand from the role planners in the DPP's office, keep the matter available for trial. So it is so. It was booked, my lord, on the 16th of May 2024.
What about this? What about these interlocutory applications?
Then that is the second thing, my lord. If the court, I'm assuming then that the court is available for the trial period that was previously booked. The second issue, and I've discussed this with my own friends, I anticipate that they will object to the trial proceeding while various appeal processes are still unresolved.
Understandably so.
Yes. And my lord, firstly, there is the application for leave to appeal against your lordship's second removal judgment. That was filed late, about 5 days late, so that it is to that is attached an application for condemnation for the late filing. But before the condemnation is granted, there is no actual application in accordance with various rules in both criminal and civil cases. So there is no application. It is to come, and whether the Supreme Court of Appeal will grant condemnation or not, we will oppose it for good reasons, I will imagine, and the court will then determine whether that ever becomes an application or whether it's an application for condemnation refused, and therefore the application refused. So that is still pending. That is the thing. And secondly, there is your lordship's judgment today.
Yes.
Obviously, my learned friends have indicated to me that they do not indicate today whether they will appeal. My learned friend for number 1 and 2 would want to take instructions and consider their options. That is perfectly reasonable. And the only thing is, my lord.
How would you have discussed that when you were not expecting me to give judgment?
My lord, there was a lot of toing and fro. We also discussed the issue of whether the state would lose and what would happen then. So we were quite alive to the fact that look, the state hoped that our arguments would prevail, but
so there's going to be an application for leave to appeal either way, whether you lose or win.
Yeah, indeed, my lord. Anyway, so in no way did we anticipate what your lordship would find.
Yes.
We're just looking at the various.
But we do know, Mr. Downer, that there are these interlocutory applications, and in the presence of these applications, we will not be in a position to set them right down for trial in July.
Yeah. So well, the state would want that to proceed, and let me just say, the state would need to argue that in a formal application or formal papers served to say we've got to the stage on this trial where the trial date was set in May 2024. We're now in June 2025. It's more than a year later. Everyone, the state, the interests of justice require that the matter proceed to trial. And in the light of the fact that various courts, including the Supreme Court of Appeal, full benches of this court and this trial court, my lord, have decided that the various applications, certainly most of them have been an abuse, that abuse should not be able to prevail and then delay the trial. So our argument will be, and I'm not making the full argument now, I'm just saying we will make an argument that at some stage, once your lordship has heard full argument from us and from our learned friends in answer, that this court should decide so long and no further, this trial must proceed, and however long it takes for the various applications to go to the Supreme Court of Appeal, either by accused number 1 and 2 or just by accused number 1.
And I'll have to write another judgment.
Yeah, that would seem so, but it would be a very easy judgment, so the state will argue.
Which will most probably be taken up on appeal.
Well, we will ask that that also be ordered, whether that should delay the trial, because ultimately our argument will be, my lord, your court is in trial. This court is in trial. Your lordship is bound by Section 168 of the Criminal Procedure Act to decide whether to grant applications for postponement. The state says carry on. The defence says no, postpone. That is an issue for this trial court to decide, whatever the status of the applications is. And we will bring argument about the effect of the Superior Courts Act and whether that binds this court, including the judgment of Kunjay, His Lordship Judge Kun, etc. But that is an argument which will be fully made. My learned friends have already been apprised that is coming. So, my lord, I could perhaps make it short and say that in all the circumstances we discussed dates. And we looked at the date in late August, the 28th of August, which is in this trial period. That would give us sufficient time to file our papers. Both my learned friends have said that they're available, the state is available. It's a Thursday, the 28th of August, obviously subject to your Lordship's directions.
Yes, unfortunately, can I just be frank with you, I won't be available in August.
Not in August at all?
Not in August at all.
Right.
I'll only be available in December.
In December?
Yes.
Right. Well then, my Lord, I would imagine that we would have to accommodate your Lordship, obviously.
Yes, please.
and
I'm indebted to you.
Yeah. We're indebted to the court. It's no means meant to bind the court, my Lord. I wouldn't try such a thing. So if it is to be December...
indicated if we are going to accommodate you.
All parties will accommodate the court, my Lord. Yeah. I'm sure my friend for Q's number 2 would as well. But December, I don't think that we would need to would need to consult further. If your Lordship would give us a date or two. 4th of December.
4th of December.
Yeah. So I'm hearing dates from my own friends. The 4th of December is a Thursday. Yeah. That obviously would suit the state, my Lord. Okay. And we're subject to your Lordship's directions, obviously. Right. Let me just emphasize that again. No, so, my Lord, unless the court would like to hear me further on this procedure, I think that is all the state has to say.
Thank you, Mr. Dana. Yes, Mr. Mbofu.
Let's go, please, my Lord. My Lord, I just want to indicate, well, the first part of my learned friend's address has now been overtaken by events. The part about the trial on the 21st of July.
Yes.
So I want to address that. I'm just going to address maybe the second part of his address about the application that they are threatening to bring. My Lord, we would then assume, and that's subject to confirmation by Mr. Downer, that if indeed they are going to pursue such an application, then obviously it would be held on the 4th of December. And then the parties would work out, yes, my learned friend is nodding, and then the parties would obviously then work out. Obviously, what we would probably do, my Lord, is work out among the parties the exchange of papers and that kind of thing, and then write to your Lordship for the blessings of whatever whatever exchange of papers and heads of argument and so on. But my Lord, I must say...
Are we talking about the proposed application for the adjournment?
Well, my Lord, no. It's not as I understand it, my Lord, it's a very serious application which seeks to compel, maybe is a strong word, but to say that the court should run the trial irrespective of what your Lordship has correctly called the interlocutory matters. Now that would be firstly an application that is unheard of, but to the extent that I can assure your Lordship that it will be opposed by us. If for anything else.
But don't you think, Mr. Mbofu, I don't mean to interrupt, don't you think that by December those issues would have resolved themselves?
My Lord, in all seriousness, my Lord, that would be the hope. Yes. And I would think with all senior practitioners on all sides, those kinds of issues should be resolved. Because in any event, my Lord, with or without that application, the court would be seized with projecting new trial dates, either way. So it might well be that application becomes unnecessary, we hope. I accept what your Lordship is saying. But this I have to say, my Lord, that, and I'm saying this in all seriousness, hopefully that application will be averted somehow, and I'm quite sure that we all will do whatever is in our power to avert it, because your Lordship is quite correct. What that means is that instead of having the 2 interlocutory applications, we'll now be introducing a third one. And the Lordship has to do a judgment, and then whoever is not successful appeals. And the point of that, it's quite obvious. And I must say that we would view that on the part of the state as some form of Stalingrad.
In reverse.
Yes.
In reverse.
Exactly. Now, and I said tongue-in-cheek to my learned friend, Mr. Downer, that we would only accept that application if they promise not to appeal if they lose. And he was not prepared to give me that undertaking for obvious reasons. But my lord, yes, the real point is that coming back to the two applications that we do have, I'll call the first one the Thales application. So in the Thales application, my lord, my learned friend Mr. Downer is correct. Both my learned friend and myself have agreed that we would obviously have 14 days within which to make a decision. We would, I'm not sure if the judgment is already typed and all that, my lord.
Well, it's a criminal matter, so if it's a criminal matter, you just have to get the transcript.
Okay. Well, I'm glad for that, my lord. I'm raising that deliberately because one of the reasons that delayed the SCA petition now was this issue about whether the judgment or the order is available and so on. But thanks for clarifying that, my lord. In that case, then, my lord, we have until the 24th of June on my calculation to decide and or file a application for leave to appeal. If that happens, then obviously, so, I'm sorry, my lord, I'm thinking on my feet, because that would also have implications on this 4th of December story. It might well be that we might have to reserve 2 dates, maybe, my lord, 4 and 5, conditionally. Obviously, we don't have to use them all up, because I'm thinking of a scenario where the state's application does materialize and the application for leave to appeal also does materialize. But those are issues we'll discuss as practitioners and we'll communicate with your lordship. But in the likely event that there will be an application for leave to appeal either by Thales or us or both.
In the unlikely event.
In the very unlikely event. Then we will communicate to your lordship the proposed time frames. Of course, the court will have the final say. So that's let's call it the Thales matter. Now, if we come to the Zuma matter, which is the removal matter for Mr. Downer, that matter, my learned friend is quite correct, my lord. The petition has been filed, albeit belatedly, and we have a duty to disclose that. But the fact of the matter is that it has been filed. I would surmise, my lord, that by the 4th of December, one way or the other, the Section 17(2)(b) application would have an outcome either granted or refused. It might well be that there will be further steps that are taken, but that will be reported to the court on the 4th of December, of course, as usual. Now, of course, the fact that it has a condemnation application and all that will also be overtaken by events, because by then, either if it's dismissed, it doesn't matter that it had a condemnation, and if it's granted, it's granted. Yes, my lord. And I have to say this, I don't want to anticipate my learned friend's application, contemplated application. But, my lord, it has to be said that these applications are centrally related to the progress of the matter. It is unthinkable how a trial can continue when two applications, one of which is about the removal of the prosecutor. When that has not been decided, then who's going to proceed with that trial? That's number one. Number two, when there's the Thales application, which has serious implications as to whether there should be a trial at all. if the issue of the death of the witnesses, if your lordship's judgment is reversed for some reason, for some strange reason.
Thank you, Mr. Mbo.
That's conclusive. But let's save all that debate for if and when the application does come. But at this stage, in our respectful submission, it would be ill-conceived because it would either induce delay but also not make sense in the circumstances.
So I still said we agree that they might be adjourned to 4 December.
4 December, maybe
possibly 4 and 5.
4 and 5, just in case, my lord. And again, if one or two of these things doesn't materialize, we'll obviously write to your lordship so that we don't waste or reserve a date unnecessarily. But to be on the safe side, I would say 4 and 5.
Yeah, that's fine.
Let's go, please.
Yes, Ms. Jackson.
Thank you, my lord. My lord, it's been correctly portrayed to you. Thales will need to take instruction on whether or not intends to bring an application for leave to appeal. That we will do within the time periods that are afforded to us, and we will report to the court should we decide, or should client decide to take such steps. My lord, I don't intend to comment on the application that the state intends to launch until such time as we receive it. Thales can then consider its viewpoints and its rights, and then we will reply in the appropriate manner should it arise. I have had communication with Mr. Roux. He is available on the 4th of December. I just wanted to make sure because the dates changed. So he is available.
And how did you do that?
4th of December. My attorney stepped out and gave him a call.
I see.
I wasn't naughty. I asked my attorney to step out and phone him. So he is available on the 4th of December for purposes of either the leave to appeal, and if an application is needed to be argued.
Anything else, Mr. Dunn?
Yes, well, thank you. I don't wish to enter argument about the merits of our pending application, if indeed it's necessary. All that I can say is that at some stage, in the abusive series of applications which have delayed the trials for years, we need to draw the line. That's what I'm saying. So, but it's not necessary to decide that now, my lord. Secondly, my lord, it was remiss of me to raise the issue of the trial date, because we clearly now have lost the trial dates in 2024. Events have overtaken us, and your lordship is not available later this year in any case. So, my lord, we need to talk about trial dates in 2026. Sorry, I said trial dates 2024, I meant 2024, which we had, and 2025. But the current trial date, which we're in the middle of now, is now lost. So we need to talk about trial dates in 2026. If we leave that to December, then my learned friends' diaries are going to fill up in the new year. We're only going to be in the second half of 2026 to the state, and I'm sure in the interest of justice and to the court that's not acceptable. So I would ask the court to give consideration to determining a trial date. My lord, it need not necessarily be done today. To reserve it, it could be done.
Can we do it in chambers? Why don't we adjourn this matter now to the 4th, and then thereafter
discuss in chambers?
You're not amenable to that, Mr.
No, my lord, I would. I don't think it would serve any purpose to adjourn and do it later, my lord.
But while we're talking about the trial dates.
Yes, I'm talking about that as well, my lord. I'm saying, my lord, there's no pressure to do it today. Once again, the parties should engage because I don't know the availability of Mr. Masuku and all that, and then we could present possible dates
to the court.
Yes, and we should be then confirmed on the 4th or something as court president.
Yes. Thank you, my lord. I'm not happy with that. Having did it to my learned friend. All I wish to say is that we don't wish to leave it, and I'm happy that my learned friend wishes to engage. We don't wish to leave it to the 4th of December before we have certainty about when we're going on in 2026. I'm sure the court will be with me in that. Yes. We'll accommodate. I'm sure the court will accommodate us, and our dates will come to an arrangement with the leave of the court, with the court's consent, obviously. Please, the court.
Right, this matter is adjourned to 4 December this year, 2025. The court will set aside 2 dates, that is the 4th and the 5th of December. Mr. Zuma and Thales do not have to appear in court on that day. Court adjourned.
All right, please.